Each side will have 15 minutes, and the appellant may reserve up to 5 minutes, and you just have to let me know how much time you want. And please do not use the names of any victims or minors, as well as keep your voice up, stand behind the podium, because we're video recording you. Thank you.
Your Honor, I would request we could reserve up to 5 minutes at the end for rebuttal. May it please the court, Your Honor, we filed an appeal on this matter. We believe that Mr. Taylor has not been afforded a fair trial.
Counsel, you do me a favor, just introduce yourself too.
I'm sorry, say again?
Put your name on the record, please.
Attorney John Kopasakis, 0090784, on behalf of David Taylor.
Thank you.
Your Honor, it is our belief that Mr. Taylor was not afforded a fair trial in this matter. First and foremost, we don't believe that Mr. Taylor was afforded the opportunity to present a complete defense. That is for a few reasons. The first one is that Mr. Taylor had a necessary material witness that the state had interceded to prevent him from being able to present. The second one was that Mr. Taylor, his attorney was going to present a certified court document that he would use in that defense. In addition, we believe that Mr. Taylor's attorney was deficient. He had a number of peculiarities that occurred throughout the entire pretrial process and then during the trial itself that would prejudice the jury and the trier of fact against his client, including diving into race relations, politics, and a series of immaterial objects or facets that we believe drove the jury against his client. In addition, his attorney failed to object when it was revealed by the state that the state had actively stepped out to interfere with his ability to call a client. During the pretrial process, the counsel for the state had outright stated that they had intentionally called down to the juvenile division so that this sentencing date could be moved so that the juvenile would become unavailable for the trial. And his attorney and Taylor's attorney basically sat there and was complaining that he miscalendared something, which was his grounds for his continuance.
Counsel, quick question.
Yes. Is there any case law where changing or a court date or manipulating a court date with the defendant is misconduct?
I have not found case law specifically on that facet, but I would argue, Your Honors, that it's akin to any party acting in a manner to interfere with a witness coming forward to court. This would be no different than a defendant who buys a plane ticket for a witness to fly across country on the day of court. While in itself would be not necessarily a criminal act, but it becomes clear that it's interfering with a witness coming forward to testify. I did cite case law in regards to misconduct on, you have to forgive me for a moment. I did cite case law in regards to misconduct. I believe it was Carroll, where the state had acted to prevent a witness to be known to the defense, to prevent that witness from testifying. It may not be exactly on point, but it is still relevant here where the state has taken a proactive step to prevent the defendant from discovering or being able to present their witness to the court. We also believe that there are a series of other minor errors that, taken together, present themselves as being deficient and had a material effect on Taylor's ability to present a complete defense in this matter, Your Honors. If the court will look at State v. Castro, or the U.S. v. Castro, the appeals or the federal appeals courts have determined that a certified journal entry would be applicable if it were material to the underlying case in the matter. The state in their brief cites Tarzan, I believe, which is an 1830s case. In that case, the Ohio Supreme Court had found that a appeal is not, or other party's conviction is not admissible in trial unless it is material to the underlying case in the trial. I would ask this court to apply the standards for applicability in, or the admissibility of other parties.
Before the trial court, what was defense's argument as to why this document would be admissible?
It would show, in terms of the trial court, defense argued that this document was indicative of the other parties taking responsibility of his guilt.
Whether they certified copy of the certified business record under 802, why the trial court said this should come in? Did they rely on 803 and unavailability when they talked about the exhibit coming in?
They relied on his availability. The issue that the judge ultimately ruled on was its trustworthiness. Judge Moraldi said that because the underlying case, or the sentencing did not directly state that he was taking full guilt and accountability, and that he was saying that this is not absolving Taylor from the charge, the underlying court document itself, that it prevented, it wasn't reliable in that sense. We believe that Judge Moraldi is wrong in that matter, that the document itself is a certified journal entry. The document speaks for itself as a business record. It is trustworthy in itself, and had McNeil, or Attorney McNeil, been able to present it at trial, it could reasonably have changed the outcome of the trial, showing that an individual was taking responsibility for that action.
That's my question. Assuming it's self-authenticating judgment entry that's relevant to your defense, how, there was quite a bit of evidence, including a residue test.
Yes.
How is your client prejudiced, even if that was an error?
A review of the court record in that case shows that the residue was shown both on the driver, the juvenile's, and Mr. Taylor's hands. A review of the record would show, the expert in that case had testified that the only way that gunpowder residue would end up on everyone's hands in that situation was if the gun went off inside the car. Basically rebutting the state's argument that Mr. Taylor was the shooter and holding the gun outside the window. Had Mr. McNeil been able to show, the certified court entry would have been able to show to the jury that another individual had already taken responsibility for the shooting, that the gunpowder residue was on that person's hands, and that the witness who testified for the state had testified that the only way that gunpowder residue would be on that guy's hands and Mr. Taylor's hands is if he had fired inside the automobile while he was driving. I believe that's sufficient to meet the standard of potentially changing the outcome of the case.
The jury found him guilty on a complicity theory.
I'm not sure if the jury
because they were instructed. That's what the.
I believe they were.
Complicity and constructive possession.
I believe though that he was also found guilty on the overall charges as well. I don't think they specified whether it was complicity or as the underlying shooter.
Right, but they were instructed that way, and that was the state's theory. Is that correct?
It was a combined avenue, so that they could find either that he was the direct shooter or the complicity. And had McNeil been able to present that, he would be able to show that it wasn't one or the other, that he was not the individual responsible for the shooting.
What did the indictment say?
I don't remember the indictment exactly, I'm sorry.
I just wondered how it was charged. Okay, thank you.
I'd have to look it up, I'm sorry.
That's all right.
Are there any other questions?
No, you may proceed.
Could I
Reserve, yeah, you
Reserve the
have
balance of my time?
5:45, so you only have 5 minutes left, if that's okay.
thank you.
Thank you.
Good morning again. My name is Mark Koza. May it please the court, I'm here on behalf of the Lorain County Prosecutor, J.D. Thomason, and the state of Ohio. Based on our response to the brief, specifically the assignment of error 1, looking at whether or not this adjudication journal entry was excluded, we would argue that 1, it was not abuse of discretion of the court, and looking at that item, it was 1, it was generally hearsay, and we specifically looked at the case of Bryza and why you would bring in a co-defendant's admission of guilt, and the reasons to let those in is 1, to impeach, or if it's conspicuously absent, or to rebut the impression of unfairness. However, none of those were present in this trial for that factor. In addition, Taylor's goal was to use SMs to disprove his own guilt, as opposed to bring in to oppose his own guilt. So we would say that 1, that it doesn't meet Bryza, it should have been entered, the court did not abuse its discretion. Additionally, it is hearsay, it does not meet the standards of 804B3, substituting for the declarant. We cited case law on that.
Is that what was argued before the trial court is the basis for admitting the document by the defense, that 804B is unavailable because he was pleading the fifth, or was there some other argument regarding why it should be admitted?
Unfortunately, Your Honor, I'm not aware that the fact to properly answer that question for you. I could do additional research. If we were to look at this additionally,
The judge got finding was on trustworthiness more so than anything else, so I understand.
that is correct, Your Honor. 1, it's just a statement of someone admitting to guilt of these offenses.
With us, I mean, there was one gun in the car, one person shot it, and the other person admitted to, and I don't know if that charge, but somebody admitted to shooting the gun. That's not just, that's a pretty big difference.
That is correct, Your Honor, but if you look at the facts on the entirety of the case, Your Honor, the gun was found in the passenger seat where Taylor was seated, in addition. So, and the court was, as we said, was instructed on complicity and constructive possession.
Do we know what the specific conviction was for in this case? Was it complicity of being the actual shooter?
Your Honor, I believe it was just to the count. I don't know if it specified whether or not there was a specific instruction as to whether it was complicity or not. It was generally given that. I would also argue that SM's involvement is not unknown. The mention of this person took place at trial. It's just that if we look at to assign, we'd then argue that, as I said, that this is harmless error if we were even to get to this level because of the overwhelming evidence of Taylor's involvement in this case. Looking to assignment error 2,
what is that evidence? I mean, he was in the car, but some of the expert testimony said, well, if a gun was shot in the car, they'd all have gunshot residue. So we don't know, we can't necessarily point that to him being the shooter. What's the overwhelming evidence you're talking about?
You're right, Your Honor. Gunshot residue isn't always the most definitive factor in determining whether or not someone shot the gun. You're correct. But he is in the car that is fleeing the scene. The gun is found in the passenger seat where he is. He initially gives misstatements to the police. So, Your Honor, you have him at the scene. We have bullet holes going in there in a car that he was in, found in a gun that was found where he was seated.
So just so if you're in a car where the driver shoots at the car, you're guilty of the crime of shooting as well?
You could be potentially found guilty of complicity as long as there's other factors that go along towards that. We have.
What were the other factors for complicity if he's just a driver that didn't, if he's a passenger that didn't shoot the car?
Well, if we have a person who is, 1, fleeing the scene and then is giving false statements with consciousness of guilt. We have someone, if you didn't get out and say, like, I didn't shoot him, it was him the whole time, he completely lied about his involvement, Your Honor. So I would say that those factors of the circumstantial putting him there at the scene create a greater argument for complicity than would just be, I was sitting in the car, my buddy just started shooting. Looking towards the assignment error 2, Your Honor, with regards to prosecutorial misconduct, would argue that the state did not commit prosecutorial misconduct on this matter. Interjecting into another court proceeding so that SM's sentencing hearing would be pushed back would be to the benefit of not confusing the jury. I don't believe there's actual prejudice, and will also avoid him committing any falsity, as we said in our brief. We also know at the time it was brought up at the trial that Taylor was trying to get a hold of SM to take responsibility. We would further argue, even if he was able to testify, his testimony would still not implicate, as we've previously gone over, the issues of complicity or constructive possession and his involvement. Looking to the arguments in assignment error 3 of ineffective assistance of counsel, the failing to obtain a continuance of SM's hearing, appellant didn't cite any case law with regards to that matter, and it's a completely separate hearing that he didn't get himself involved in. Additionally, he did ask for a continuance on this case to try and get it pushed back after SM's sentencing hearing. Looking at the closing argument in that assignment, I don't believe his performance was deficient. He, like many defense counsels, there were a myriad of ways to bring reasonable doubt into the matter by saying there's no eyewitnesses, looking at the quality of the investigation, getting into such arguments of government overreach. We also look at, specifically I think, important to the context of the statement that the appellant brings up about the cowboy incident, or this was just a boy. It was not him implying that Taylor was just some kid who shot off a gun. It was him implying that there's no eyewitness. The context of this is it could have been anyone who shot off the gun. Additionally, we would state that there was no fundamental errors, so that there was no cumulative errors in this matter. Thank you.
Thank you, counsel. You still have your 5 minutes.
Thank you, Your Honor. Your Honor, in regards to Bryza, while it does set out factors in regards to when it is applicable to apply the co-defendant's conviction to a matter, it's not definitive in that regard. These aren't the only 3 reasons why you can bring up a co-defendant's conviction, and I believe that's so that in the event that it is relevant to a case, a party can bring a co-defendant's conviction. The underlying idea here is that the defendant is, acquitted or convicted on his own case, not necessarily because somebody else's case went first, or the defendant the co-defendant, lost the nerve to go to trial or something like that.
I do have one question, and that is, you keep calling it a conviction, but it's an admission of an offense, and he
Correct,
was
Your Honor.
found delinquent. Do you think that makes any difference here in the analysis?
I don't think so. From my understanding, it's still a statement against interest. He's still under legal jeopardy, and he's going to still suffer consequences because of that legal jeopardy. I believe under 804, the idea being that we can trust this statement because people would not make these statements unless they were true, because it's completely against their own interest to make these statements. I believe the case in Castro, the individual had called a friend and then came up with a note, and in that note there was no real risk to the person who was making that statement because it was very untrustworthy in that situation. I believe that's the whole purpose of making that aspect of the rule. It has to be verifiable. You have to be able to verify what is the interest here, whether or not the statement is trustworthy. In regards to the co-defendant or the minor as taking responsibility, we really don't know what he would have testified to. Whether or not he would testify that Taylor was or wasn't complicit, we never really had an opportunity to know because the state interceded to make sure that SM could testify. They purposely found a way to get him off the table, so to say.
Did counsel below ask for continuance after the counsel discovered that that admission was not going to come in? Did the court say, well, then I want to continue this till after the sentencing? Did counsel below ask that?
I don't believe he asked at trial. He asked at the final pre-trial, but it seems almost like he was distracted by his own calendaring mistake.
It seemed for a while that it appeared, from what I understood from the briefs and the records, that the trial court initially was going to allow the admission in.
Yes,
And then the trial court changed its mind and said, well, no, never mind, I'm not going to.
yes,
So at that point, the court changed its mind, counsel did not ask for continuance at that point.
he did. No, Your Honor. And I think that goes to counsel's deficiency in that regard. He should have called SM as a witness at that point. If he did not have his The crux of this case from day one was that SM was going to take responsibility for these actions and acquit his client. And he went through the entire legal proceeding without having his main thrust of his case there, one way or another, whether it be the witness or at least at minimum the journal entry.
Counsel, how do we get over the aspect of conjecture, whether this was right or wrong? We still have to demonstrate prejudice or counsel, you have to demonstrate prejudice or counsel was ineffective and prejudice his client. So the fact that, okay, he wasn't allowed to testify, how do we know what he was gonna say?
I believe the standard is a reasonable probability of an outcome. It wouldn't be that we know for sure that Taylor would win at trial. It's just that it's probable that he could possibly win at trial.
I guess what I'm asking is, why is this not more appropriate for collateral attack through post-conviction?
I can't answer that question. I would be able to tell you, I'm sorry.
That's okay. You have just about 30 seconds left.
I do know that one of the standards in regards to that is whether or not it causes a trustworthiness in the conviction itself. I believe that what has occurred in this case undermines that underlying conviction. We don't know for sure if Taylor was the person who was the shooter in this matter or complicit in that regard. Thank you.
Thank you. Thank you both for the arguments you made, the presentation support. Everything will be taken under advisement, and a written opinion will be sent to both of you. And also, it's released from the Supreme Court website.